Hey, I think we are ready to get started. We've got a little bit of an update on the Voron. So let's look at that for a second. So I did find a blower fan. This is the kind of fan that went out on the side over here. The only problem with this one is that it is a 12 volt fan. So I don't know, you probably can't read the label there, but it says 12 volts. These are all 24 volts. So what I had to do is had to go over to the Voron bill of materials and find out that they are using the 3010. 3010 refers to 30 millimeters by 10 millimeters. These are the blower fan types, 24 volt. Then go over to Amazon. Looks like I've already bought some of these, a year ago. Maybe that's the ones that are in there. I don't know. I actually think these I put on the little rope printer. So, gonna have to buy some of these. Fortunately, it looks like these already have the plug, at least the picture does, of where it's gonna plug in, and that's how I have this one set up. I have a little pigtail where I can just plug in new fans versus having to solder them in. So, looks like I'm gonna have to order some of these before we can fix that part of the Voron. It does still print. It did not finish printing. I don't even see. I must have thrown it out. Last time we were printing the little Flexi Chameleon or something like that. I don't actually remember what it was now. And it was printing it okay, but I stopped it, I don't know, maybe 20% in, 30% in, something like that, because the layers were, it had shifted. Remember I'd said that I was afraid the way I have the spool mounted back, back there, just in a container, that the accelerations were going to be so high that it would want to move really fast. Oh, it's locked right now. Oh no, it's just stiff. There we go. It was going to move really fast and pull on the filament, and there wasn't going to be a way for the filament roller to respond fast enough. And sure enough, that happened, and it lost its place and shifted the layers. And so I need to work on my filament support system back there. This is apparently not going to work on a roller like that one anyway. Or I need to reduce the amount of acceleration to something a little more reasonable. I think the acceleration was really high on it, at least the max acceleration. So that's what's going on with the Voron. We're actually not doing something that's directly 3D printing related today. I do see this guy though, so I guess I'll show him. We had a couple of classes ago, we did some resin printing. This guy's another example of what you can do with FDM printing, though, so that you can actually see on the bottom. FDM, I don't know if you can see on the video, but there are a lot of models out there that work just fine with FDM printing. This one's not even a particularly thin layer height. I probably 0.2 millimeters. Maybe you can tell on the side there. I don't know. You can kind of see a couple of little striations in the rock of the layer heights. So you can get totally fine models out of FDM printing. You don't have to deal with the resin printing. I was going to do, if there's interest, I was going to do a video on finishing models. Like what do you do once you've printed it? How do you get it to be colored or painted or whatever you're going to do with it? So I think maybe the next video, Fridays, will be a little bit on just an assortment of ways that you can finish models. I have a couple of different models around here that are finished in different styles, and I'll talk through some of the different ways that you might finish a model to make it look metallic, or make it, how do you paint them, how do you smooth them out, all that kind of stuff. So I think that's what Fridays will be. Today we're doing something a little bit different. It is related to 3D printing in a sense that we take it, but we don't always think about this part of 3D printing, but we're going to talk about the intellectual property side of 3D printing. So this one's going to be a little bit more of a lecture, and we're going to cover just a generic overview of intellectual property and some of the ways it relates to 3D printing. It's actually confusing and not really well defined area right now. But there are some prior examples in similar fields where we can maybe anticipate what the laws and rules might be. So I do have this one. If you have the canvas open, you could follow along with this. I'm gonna this is a PDF, not PowerPoint, but a PDF of what we're going to talk through. So we'll just look through that. Let me get it on the screen so it's not chopped off there. Let's see. Let's get that maybe like that. All right, there we go. That looks like it'll probably work for us. All right. So, what is intellectual property? Now, most of these are going to be confined to the United States. Different countries might have slightly different laws and rules on intellectual property. So these are going to be particular to the United States. Some of what we talk about will be transferable to other countries too. So in general, intellectual property, or IP, is some sort of asset that's a product of the mind. So some person or people, a group of people, thought up a process or a product or maybe even a service sometimes, and they have conceived this idea, and so they've got it, and it's a little bit more than just the idea of it. Usually there's an implementation. Sometimes there's not. Sometimes there is just the idea, but there's this asset that some group or person has thought up, and we call that intellectual property. So it's something that someone's intellect created. Here are 6 common types of intellectual property. So the one that most people think about when you think about intellectual property is patent. So that's the one that you think about first, most of the time. In fact, there are multiple kinds of patents even though, so there's not even just one patent type. But that's what most people think about. But there's other forms of intellectual property, copyrights. So that's, okay, once you think about that, like, oh yeah, that's intellectual property. Trade secrets. There are some things that there are reasons you wouldn't want to patent or copyright, or well, copyright's a little bit different. But maybe you don't want to patent something. You just want to keep it a secret. So that can be intellectual property, is keeping something secret, your secret formula. Trademarks. So those are, you want to protect those. Usually we're thinking of intellectual property in the sense that it's something we want to protect. And trademarks are going to be related to your brand if you're a company in some way. Sometimes it's just data. So all of the stuff that, now every time you go to a website, there's a pop-up about what cookies they're going to want to collect, and you have to accept them or decline them or whatever, or manage those data things. Companies are collecting data all of the time through your apps, your social media, the software you use, the products you buy at the store. And that data is maybe not necessarily something that someone thought up, but they thought up ways to use that data. So they might sell your spending habits to a certain company who wants to advertise to you so that they can figure out the best way to advertise to you. And so there's all sorts of reasons that companies might find value in that data set. Sometimes it's just know how, show how. So you know how to do a particular thing, and you go around the country showing people how to do that thing. You'd like for your process, whatever it is, to not be copied. You know how to paint pictures, and so you go around showing people, doing these little workshops on painting, and you don't want one of your students to just go and exactly copy what you did. So there's some, protection there that you might want to invoke. So these are common forms. There's all sorts. Each one of these has their own little categories underneath them. But these are the main categories of intellectual property. So like I said, I was going to mainly talk about U.S. Intellectual property. So let's start with the patents, since that's what most people think about. 3D printing that we know today, the consumer version of it is largely possible because of our patent system. So the way our patent system works, and most of them in the world work, is that the deal is that the inventor or inventors have to fully disclose to the public how they did their thing. So 25, 30, no, more longer than that, 30, 35 years ago or so. I'd have to look it up to see. Maybe we could find it. A company disclosed how the FDM printing process worked. And it's not a big thing on how to figure out how it works once you see it, but they disclosed it, and they have a patent on that, or they had a patent on that, and the public knew how to do everything because of the patent, or because they saw the printers in action and could figure it out. But what the deal with the patent is, in exchange for that public disclosure of how it works, is you get protection from people making money off of that process or that product in whatever country you filed the patent for some amount of time. In the United States, that's 20 years. So after 20 years, that first set of patents on FDM printing expired. They started expiring. There was a series of them. And suddenly, the public has this information about how this process works, and they're not held back from making money from it themselves. So they could start making kits of printers where you could build your own printer using the FDM process. Before they couldn't do that. You could build your own. Like as an individual, you can go see every patent that's ever been published. They're all online from 1976 to now, and then even some of the older ones are online where you can go look at all the patents. And so if there's something you wanted to do, you could, if you had the skill and equipment, you could go look at the patent, figure out what they're doing, do it yourself, and that's fine. It's when you started wanting to make money off of that, you wanted to figure it out and then sell not your idea, but your version of the idea. That's the problem, at least for those 20 years of protection. Once that 20 years expires, then it's open. It's called public domain. So anybody that wants to could put a kit together, and this is what started happening. Some of the I have one of the early kits. It's let me see if I can find a picture of what it is. I don't have it here in my office. It's one of these guys. So I have one of these in my office. This was one of the very first kits that you could get, where it's all laser cut plywood. There's a controller that's basically an Arduino with a shield on top of it, power supply just straight out of a computer, some stepper motors, and a little movement system. But they could do this now because the patents that were protecting this technology had expired. And so this kit was, I don't remember how much it was. It was actually like maybe $600. I don't remember. It was kind of expensive though. I wonder if this link tells us how expensive it was. Doesn't say there. So these did print. This print volume here, I believe it is actually smaller than the little V0 over here. Well, over here. The printer was about this size. It's a little bit bigger, but I think the print volume was even smaller than that. But it was a thing that you could do. So, and it was legal now. So, the other parts of a patent are, you can't just patent obvious things. So it has to be novel, new, has to be not already patented. So you couldn't take an expired thing from 50 years ago and repatent it. Once that idea is patented, you can't repatent the same thing. There's the protection I talked about. Oops, I didn't want to actually move that. I wanted to highlight it. There's the protection I was talking about, where the owner of the patent, the assignee of the patent, gets to choose how the patent is enforced. So the government doesn't go in and enforce the patents. They just give the owner or the assignee of the patent the right to enforce this protection. And then the patents are filed with USPTO. So you could go, in fact, here's uspto.gov. You could go here. USPTO is U.S. Patent and Trademark Office, so trademarks are also in the same area. But you can go over here and go for your patent, maintenance fees. How much do you have to pay once you have a patent? How much does it cost to file a patent? It's actually pretty cheap to file a patent. I think here's the fee schedule. Application filing. So depending on where you qualify, anywhere from $320 down to, if you're a micro entity, so like a single person who's never filed anything before, or I think higher education also qualifies in there, $64. That's just the filing fee though, and you can kind of see that's for a utility patent. Here's a design patent, design CPA, a plant patent, a reissue, that's a different thing, a late fee, all of these different types of fees that you might, which one do you fall into? But it's actually relatively cheap to actually file the patent. The expensive part is filing a patent that is going to be granted and is useful. So it actually costs you, if you were to want to file a patent that is going to be enforceable and you've never done it before, it's probably going to cost you $10,000 to $20,000. And most all of that money is not going to file the patent. It's going to patent attorneys, patent lawyers, to write the thing in a way that is useful. So it's one thing to have an idea and then to kind of maybe throw some pictures together and a little description and send off your $64 as a micro entity and get it filed. But there's a really low chance that that's going to be worth doing at all. So let's look at, what do I have here? Oh, well, first of all, currently, as of, this is May, this month is not May, but the data is from May, there are 785,000 patents in front of you that are waiting to be decided on. So you're going to have to wait a while. These are continued examinations, so they've already been filed, and there's some kind of, usually there's a question, like the patent office might say, hey, this looks a whole lot like this other thing that was patented back in 1982. How is it different? And you have to respond to that. Here's the breakdown on utility, plants, and reissues of patents. Only 330,000 of those. There are 8,000 patent examiners on staff right now. Let's see. Oh, let's see. Let's look at the backlog here. So that's the number of applications, but how long does it take before they're actually decided on? Response data. There we go. No, that's not what I want. Pendency. So they're pending. In fact, you've seen possibly some products that have patent pending on them. They don't have a patent number. They just say the words patent pending. What that means is that this person or this product has been filed for a patent, but right now it's taking 20 months for the first action, which may not be the patent's awarded. It might just be some questions or some follow-up stuff. But over a year and a half of waiting of your 20 years that the patent could last for, you're just sitting there waiting to hear back, is it going to be awarded or not? So some people are anxious to get their product to market, so they put patent pending on it and they send it out there and just hope that the patent is going to be awarded. Otherwise, other people actually could copy their patent pending thing if it's not awarded. And otherwise they lose time, though. They lose 20 months. Traditional total dependency, or pendency rather, is nearly over. It's over 2 years before you actually get the final word that your patent's been granted. So that patent pending phrase is useful because it says that, hey, I've applied for this, and don't copy me, because there's a really good chance that we're going to get approval for a patent, and then I can sue you for copying my work. it is also illegal to just put patent pending on things that you haven't actually applied a patent for. So don't go writing patent pending on things and think you're protected, or you might be protected. You're actually, I think the fee for that, the fine for that is maybe $200 something. It's not a huge fine, but I think there is a fine if you were called out on putting patent pending on something that's not actually patent pending. There is another type of patent that we haven't seen here, and that's called a provisional patent. And what that means is that you are pretty sure you're going to file a patent, but you want this provisional protection. You want to go make some contacts in industry or somewhere to make sure that your idea is good. And so a provisional patent gives you a year of provisional status you don't have to file the full-blown patent application. We'll look at what one looks like in a second, because it's pretty lengthy. But you just file a simple form, and you have a year to go collect, go show off your thing, get some feedback and data, and then decide if you want to file the full patent or not. And so that's a provisional patent. Utility patents, those are the things that you normally think of as a patent. Like I have patented a wrench or a product of some sort. It has some utility or function. But there's other things like design patents where I bet, here's one of these things. I bet there's a design patent on this shape, this shape or the shape here or whatever. The colors that people use on their products, the shape of the product container, that kind of thing. Those are actually stuff you could file for yourself and get pretty easily. They're more protecting your brand than your product, but sometimes that's just as important as the product. And so that's a design patent. Like I said, the duration is 20 years from the date of first filing. That's why you file the thing, and you wait 2 years to hear back if it's approved or not. But that counts in your 20 years. The design and plant patents only last 15 years. Plants meaning actual like vegetables and stuff. Any kind of seed plant, I believe. I guess it doesn't have to have a seed. Plants, crops, stuff like that. Not specifically just one that you find out in the wild, like you've discovered it, but ones that you've engineered. How 3D printing fits into here is there's a weird thing that happens with 3D printing where if I have a way to produce the files that maybe this thing, I could copy this, by scanning it. We did some photogrammetry a couple of weeks ago. We could scan this in and print out our own version of it. Now this is metal, it wouldn't be metal, but I could make the shape. So have I violated a design patent on that thing? Certainly if I try to copy this and sell it as one of these things, or at least as building off of that brand, then I probably have violated a design patent. If I scan it in and print it and just set it on my shelf, that's probably fine, because I'm not harming anything economically by printing one and putting it on my shelf. It's when I start to try and sell it based on somebody else's idea that probably is a problem. But I didn't actually take and sell their thing. I recreated it in a different medium, so it's a little bit confusing. But so this is where 3D printing is starting to, clash with some of the intellectual property laws. Is what are you actually doing when you 3D print something? I'm not recreating the same thing. I've got a copy of it. Is that the same or not? I don't know. And so there's a little bit of complexity in how intellectual property and patents and 3D printing. Can you actually patent the file itself that makes something? So that maybe the end product is 3D printed. You can go to Thingiverse and all sorts of websites where, let's just go to one and see. So here, this little thing. So there's a license right here. So this is a Creative Commons Attribution Share Alike license. So that's not actually a government thing, though. It's just sort of a um, an agreement. So actually, this one says see the legal code. I actually want to see what that says because I don't know. Um, well, this is an older version. See, Creative Commons Corporation is not a law firm and does not provide legal services or legal advice. It's just sort of a public agreement that you work with in open source. So does that even have any real bearing or not? But what this one is saying is that what we want you to do is you are free to share. Okay, so I can take this file and I can copy and redistribute it. And this one actually is even commercially. So this one, the license that they want you to follow says that I can commercially benefit from this thing. I can remake it in different ways. I can take their file and modify it. Under the following terms, I have to give credit for the original designer. So whoever, let's see, Loomer underscore. So I have to tell them that, hey, at least where I got it from, Loomer underscore said that they're the person that created it. And I have to be able to, if I create any derivatives, they have to have the same license. So I couldn't change it up in some way and then lock it down to where I don't want other people sharing it. So in this case, this particular one says that, hey, if you want to, you can go print these things and sell them. These would probably actually be pretty good little things to sell. In fact, if you go to sites like Etsy or what's the other one? Well, eBay. But there's another one I can't think of right now. But sites like that, you can probably find this thing, fidget spiral cone, being sold on there right now. Let's actually see and test that. I don't know. I haven't looked, but let's find out if that's true. Spiral fidget. Yeah, look at it. They're all over. Slightly this one looks like, oh, that's a large version. Some of them have been changed a little bit. There's another one. There's another one. There's another one. You could have yours on here. You know, there's exactly the one from Thingiverse. So hopefully, let's see. Hopefully, these. This one says made by Innova Layers, but do they give the attribution? There they are. So there's the little attribution saying that, hey, we didn't make this thing. We found it on Thingiverse. They said we had to attribute this design to Loomer underscore, and so we did. And now that they haven't sold any of these, apparently, they have 0 shop reviews, but that's one way where the system is working, but it's just kind of working because it has an agreement, but not really any laws behind it. The common Creative Commons license doesn't have any real laws behind it. It's just sort of a open source agreement, but it's working in that case. So let's see, what else were we where were we at? So that's one example on the fly of how 3D printing is working and how you could use it. You could go do the same thing. So if you don't even want to question it, you just go to, you know, all of the sites, Printables, Thingiverse, all of those, they will usually tell you what kind of licensings does that file have. So like we pick another one and it may not have the same license. Well, and actually it does. It says it's share alike. And so I think that means share means even commercially. So you could probably find this thing, whatever it was, this little articulated starfish. So there's a lot of these things where somebody's made something and they may not even care if they make money off of it, but they just wanted to make the file. Some of them, they will not let you do that. There's other sites where you've paid money for the file. Typically, those actually don't want you selling the file, so or selling the results of the file. Although I'm a little unclear on what the legal system laws are on that. So I've got a couple of examples later in here of similar instances, not 3D printing related. I don't know of any large 3D printing related court cases that have made decisions yet, but there are similar digital file type stuff in the past that have made decisions. All right, so we talked about public domain already. Trademarks. So we won't spend as much time on trademarks, but trademarks, you've got TM, the circle R, you've got the circle C here. That's actually a copyright, not a trademark. Trademarks are things that are more related to your brand. They just fall under the general category of intellectual property. And let's talk about the copyright first, and then I think we'll do the trademarks. Copyright, so you've seen these circle C's somewhere in a date, like 2024 or whatever. Copyright's actually an interesting thing in that the instant you create the thing, the the written work or the picture or whatever it is that might be copyrightable, it actually is copywritten. This circle C means that you have registered the copyright. This is a different thing over here. So the copyright is protecting the expression. So the keyword here is expression, not the idea. So the expression would be the statue or the book or the play or the music score or whatever, the actual instance of the thing that you thought up, not the idea of the thing. So you couldn't say you've copyrighted a landscape. You've copyrighted a particular picture of a landscape that you painted, but not the idea of a landscape. That's not what it's talking about. So the it doesn't matter if you've published the thing or unpublished it. So it doesn't. As soon as you wrote it down, it is a copyright exist for it. And it is similar to how patents work in that you, the creator, the author of the copywritten material, you have exclusive rights for people copying that stuff. So that's one of the weird things about here, because the actual thing is, it's a STL file or some kind of geometry file, and that is just a bit of code. So you didn't write the code necessarily. You created a geometry and then some kind of slicer or some sort of program converted that over to this code that you could read if you wanted to dig through it or whatever. So is that copywritten or not? There's some weirdness on what part is actually copywritten on a 3D file. But whoever created it has exclusive rights for saying how it gets used. You can grant a license, meaning that you could say that, hey, this group can publish my work, and we've agreed how it's going to work. They bought it out totally, or they're going to give me a royalty, or I'm just going to let them do it for 5 years and then it goes back to me, or whatever. There is this fair use. You might have heard of that before. That shows up in academia a lot. You see on YouTube, there's a lot of reaction videos. I don't know if there's as many right now as there were a year ago, but there were a lot of reaction videos. And so what they're doing there is they would play a song and they would react to it. And they wouldn't just play the song and then react. They'd play and then they'd pause it and react a little bit, play and pause, talk about it. And what they're relying on there is this fair use doctrine. So there are some things out there that are copywritten, and the copyright does not want you using the thing at all. So they want to own the exclusive profits in any way, form, shape that might generate profits. And there's this fair use doctrine that says, well, no, if you've published something, then the public ought to have rights to comment on that. And so you don't have to, in a reaction video or you're looking through a textbook and using some of the text there and commenting on it, then you fall under this fair use. You can't just play the whole video and then comment at the end. You have to comment in throughout. You have to, you can't just provide the whole thing, the copywritten thing, uninterrupted in any way, and then later on go in and talk about it, because that's basically, the whole work is the thing that's copywritten. And so there is a fair use doctrine. You have to be careful with it that you use it correctly, but that does let you use copywritten material in sort of an educational commentary type of way. Let's see, do I have another copy? Yes. So the period for copyrights are really long. So it's the life of the author, so whoever generated the thing, plus 70 more years. So, well, for works created after January 1st, 1978. There's some caveat there. So that caveat, usually, I think that one reply is a response to the copyright law being kind of updated then, because it was getting close. I think that one is from Disney. So some of the Disney characters were getting close to being public domain, and Disney was still clearly making money off of it, and so they just wanted to get ahead of the game. I don't remember if that's the 1978 one, though. That could be another one, similar circumstance where things are being updated to expand the length of the copyright time. I think before it wasn't 70 years. I don't remember, but I think that one was related to Disney. It was only just this last year that some of the Disney characters, the oldest of the oldest Disney characters, entered public domain, because things like this kept happening. A lot of it was from Disney, and other people are interested in it too, but keep extending the time period to keep protecting stuff that's still in use. Most things that are that old, they're not popular anymore. They're not things that need to be protected, so they enter public domain and nobody cares. But some things that old are still making money, and so they were still trying to extend these protections. So I think the old Steamboat Willie version, I think it is actually in public domain now. Let's see if I can. Let's see. The earliest version of Mickey Mouse in the 1928 Steamboat Willie, so he's in public domain. So what that means is that not the current version of Mickey Mouse, but the old version entered public domain, and you could use that version in a commercial or, well, in any kind of way, because it's public domain now. So I think I noticed that maybe maybe longer than that, maybe like 5 years ago, Mickey Mouse, like on Disney, he started looking a lot more old vintage style. There were some cartoons and some instances where he was not the version that you're familiar with, and I think they were probably trying to re-up, trying to protect that old version. So it's probably a little bit different. I haven't looked close enough, but it's probably a little bit different so that they can claim that version is still being used in some way. So I don't know if that's what they were doing or not, but it was just odd to me that Mickey Mouse kind of changed a little bit 4, 5, 6 years ago, something like that, in some of the cartoons, and he looked similar to the older stuff. So anyway, copyright has a really long time period, and you didn't even have to file for it. You could it just exists. So one thing about the existing versus the registered. So copyrights are registered with a Library of Congress. Right there, Library of Congress. But you don't have to do it. It's a smallish fee, I don't know, a couple $100. And you can do it yourself. You don't have to hire anybody to do it for you. But the thing with it is that if you don't register, so if you don't register, like at this PowerPoint right here, I don't register it under any kind of Library of Congress thing, then if I'm afraid that somebody has taken my writing here and used it commercially, I have to go and prove the damages that they created, the monetary loss that it generated to me in order to sue for those damages. If I register the copyright, so I use the Circle C, and I go to the Library of Congress, I'm able to put this Circle C copyright on here instead of just the word copyright. Then those damages, I don't have to prove them. I think it's like $200,000. I'm not sure on that number, but it's something like that. I can just sue for $200,000 without having to prove that they created that kind of damage. I just have to prove that they copied my thing. So that's the benefit to the registered copyright, is you don't have to prove damages. You get some baseline that's actually pretty high that you can just use. Now, if you want to prove more damages than that, then you have to do that. But I think it's probably around $200,000 of you don't have to prove those damages. Difficulties arise in enforcing copyrights on digital files. So I do have the example of the digital. So Sony versus Universal Studios, I think. So Sony, their electronics company. This is back in probably the 80s, I guess. I have it listed later on, but back in that time frame, maybe even older than that. They invented the technology for Betamax. So Betamax is like the predecessor to VHS. So you could record stuff on a little tape, or actually a kind of big tape, and record it off of your television screen or whatever the Betamax is connected to, and then you could replay it later. And so Universal Studios was like, wait a minute, I think it's let's check and make sure I've got the right players here, and I'm not giving somebody the bad name. Let's see. Yeah, Universal City Studios. All right, so I don't have the date here. Let's see what date that was. Let's see. This was, well, no, that's docket number 83. So it was argued in 1983, decided in 1984. So early 80s. And the idea was that Universal Studio, or Universal, what are they called here? Universal City Studios was producing copywritten work, and Betamax was making it possible for people to copy that. Now, the actual decision ended up being that, no, it's fine for Betamax to copy something that was freely broadcast anyway. Betamax isn't even the person that's doing this. They just have the technology allowed to do this. What they were afraid of, what Universal was afraid of, was people buying the Betamax technology, copying their freely broadcast stuff like over the public air, and then reproducing it and somehow making money from that. But this case was decided in favor of Sony, in the fact that, no, you freely broadcast this, and it's not an obvious jump that people are going to be able to make money from that. And so, in fact, here's that word, fair use of copywritten works, and so it was okay. So that's sort of one early case on what does it mean for a digital work. These broadcasts were, being broadcast out there. Yeah, I guess broadcasts were being broadcast. And then they were being captured and digitized in a way. What does that mean as far as copyright goes? In this case, they were saying that it was fine to do that. So maybe that leads some precedent on, at least on the 3D printer companies. So Sony's the company that created the technology. So the 3D printer companies are okay in creating technology that makes it possible to reproduce other stuff. So that's at least one thing. Doesn't really say anything about, well, it probably is illegal. You've seen all the little FBI warnings at the beginning of movies on a CD or a VHS or whatever, where there's a really large fine if you try to make money from reproducing or selling or broadcasting and paying admission for one of these, playing one of the DVDs or something. You have to have special permission to do that. So there's a lot of confusing pieces in there. We're not really going to figure any of those out in this. I'm just telling you what the rules are. So for copyrights, you should be aware of, if you're the creator, what people might do with your copywritten works and how you can protect it. I don't think there is a copyright for the files used to create a object, a 3D printed object, that I know of. But you could probably, there are some methods like DRM type things that people are trying to figure out on if you want to protect the file itself so that people can't copy it without some license key or whatever. And I think you can, like you could a CAD file, you can copyright the actual file. What does that do for the file being used? I don't know. This part is more like the statue type of thing. Like if you could use the printer to create an original work of art, so you went in and created an original piece in a CAD program and then you printed it out, then if that's the purpose, like the artwork is meant to be 3D printed, then you can copyright the physical object. It's a little bit strange because normally there's only one of these things, you know, there's one painting or whatever, but even paintings have prints that can be made and sold from the painting. So there are some similar types of things. Patterns, there's actually maybe the closest thing to this is there's actually a much older ruling in place. I just thought about this on patterns for making dresses and clothes. Let me see if I can find that. So see, now I don't always trust the AI overview thing you get in Google now, so you'd have to go and confirm this, but you can go to places like Hobby Lobby or some place that sells fabric, and you can usually find patterns where you could cut the pattern out and cut out the material to the shape of the pattern and then make this dress or whatever you're going to make. And in the United States, patterns are generally not eligible for copyright protection because they that would fall more under the pattern itself is not the point. The point is the making of the dress, and the pattern is kind of like a tool or something. So it's more like should be patented or something. So that ruling might. Oh wait, is this the pattern? Oh wait. This is kind of confused. I think the AI is confused right here. Here's a clearer thing. It doesn't extend to colors if you create original sketches. The sketches are protected. The way that are cut and pieced together is not protected. So the pattern in that sense, I think AI got confused here on patterns like polka dots and checkerboard versus patterns meeting the instructions. So the instructions are generally not protected by copyright. So the 3D file, the STL file, the G code, I guess. The STL file is different from the G code. So there's all these little intricacies that people are still trying to figure out. Let's see what else. Talked about trade secrets briefly. Trade secrets are the things that you don't want to file. Like there's a secret that you're pretty sure people can't figure out, and you want to just keep it to yourself. So the formula for Coca-Cola is the classic example of that, where you're pretty sure that they can't get the exact ratios. They might know the stuff that goes in it, but they may not know the exact ratios of stuff or the processes. And so if you patent that formula, you have to tell everybody how it's done, and you don't want to do that. And so you just keep it secret. And so for, I don't know, 100 years or however long Coca-Cola's been around, they just kept it secret. There's actually an interesting example of, I think, one of the Coke employees managed to get all the pieces of the formula and take it to Pepsi, and they didn't want to have it. I think that's true. Let me check if that's true. Or Coke secret recipe sold to Pepsi. The Pepsi company, if this is a way, yeah. So this person tried to sell the secret for $1.5 million, but Pepsi actually didn't buy it. So they actually turned him in, and he didn't get to sell it, and he actually got arrested, I suppose. So they just decided that it's more important for us to keep it secret, like actually protect it with criminal laws like stealing and trespassing and things like that. There are a couple of laws here. The Uniform Trade Secrets Act, I guess that's more of a group. But then there's the Defend Trade Secrets Act of 2016, which is a federal law that describes what you can do to keep things secret. Obviously, safeguarding secrets is hard to do because you have to be really confident that you're going to sell this product or this service or whatever, and people aren't going to be able to figure out how you did it. It's really easy to reverse engineer most things. Probably with Coca-Cola, you could probably send it through a mass spectrometer and figure out the ingredients at the right ratios and actually reproduce it. Would it be worth it? I don't know, but you could probably do something like that. Print files are digital, so that's relatively easy to read or reproduce. So how are you going to secure those files? There are DRM type of methods that are being experimented with. There's some other methods that are trying to embed the copyright in a way in the file itself. I don't know if that ever went anywhere, but I saw some a couple of years ago about they were trying to embed like their logo as part of the file internally, but you could just edit the file. So I don't know if any of that ever actually came about. But the advantage to the trade secret is that you don't have to tell anybody. That's the whole point. So you can keep it a secret. The disadvantage is you have to manage to do that somehow. That does make me remember one point about patents that I didn't really mention that strongly, is that I said the government doesn't protect the patent. You know, it just gives you the right to. That's the hard part. So if you as an individual or a small company manage to get a patent, the only good it does you is your ability to enforce the patent. So you're just relying on the fact that maybe your idea is not interesting enough to be stolen, but let's say that one of the really large companies wants to infringe on your patent. In order to stop them infringing on your patent, you have to somehow take them to the court system, which they have way more resources to deal with than you would. And so if you'll see a lot of times mergers and acquisitions and things like that, as a small, maybe a startup or a really small company or even an individual, your probably better course of action is, if you do get a patent, is to take it and just sell the patent. You know, don't even worry about trying to protect it. But if you don't have those resources available, like you yourself are not a patent attorney, you don't have the funds to protect it, then a lot of times the better option is to just, if there's a company interested in it, to sell the thing, or to lease it to license it to them. That's not always the best thing to do, but it can be really tough to actually protect your patent. The government doesn't actually do that. They just give you the mechanisms to do that. But you have to go and take them to court and hope you win, and hope it's that the fees can be paid for, and all that kind of stuff, not out of your pocket. So it's kind of hard to do. We talked a little bit about trademarks, service marks, word marks. These are all versions of the same type of thing, but they're all related to building your brand identity. And the Lanham Act is what governs how trademarks are dealt with. These, let's see, I showed these symbols here. This TM, you can just put TM on something if you want to. If you come up with a cool brand logo or name or whatever, you can put TM on it and say, I'm trademarking that. And it's kind of like the copyright, where if you don't actually go and register, you lose some of the strength of the protection. So TM just means that, hey, I'm trademarking this, and I'm not going to go file it or anything. The circle R means it's a registered trademark, and that means that you can you have the governmental rules behind you that you can rely on for protecting that trademark. Let's see. They have. I don't think they ever run out. They run out when you stop using them. Trademarks. So you do have to show that you're actively using a trademark. If it's shown that another company or another person wants to use that trademark and they can go and demonstrate that you haven't used that thing in 25 years, I don't actually know the time period, but in a long time, then they can apply for the trademark. They're at the USPTO. They're not mandatory, but you get enhanced legal protections if you do register them. And it's a couple $100 to register a trademark. Trademarks are a little bit different from the other things in the sense that you can have similar trademarks if they're in completely different categories. Like you could have a similar trademark to some other company if the other company does, I don't know, baby toys, and you are over in, I don't know, I don't remember all there are thousands of categories. Maybe we'll look at them in a second. But you're in some completely unrelated category, then you can be reasonably sure that you're not going to be confused with them, and you can probably get a similar trademark in an unrelated category. Let's see. Here are some of the things that I have tracked down that are related to 3D printing and intellectual property. Like I mentioned earlier, DRM, people are trying to get DRM into 3D model files so that they can control how they're used. It's going to be tough to do that. You can see all sorts of examples of DRM in like video games and things like that where it can be broken if people want to break it. So it's still a little bit hard. The DRM, that's where I mentioned the Sony versus Universal City Studios, where they were trying to, Universal City was trying to say that Sony was infringing on their copyright by producing this technology that could copy their stuff. If they're original works, you can copyright the CAD file if it's an original. You can't just, take somebody else's and copyright it, just like you couldn't take somebody else's book and copyright it. The printed product can be copyrighted if you think of it as an original piece of work and you originally created the design file for it. We talked about fair use. There's a couple of case laws. These are the ones that I was thinking of that kind of relate in digital reproduction. So Capitol Records, music, and Authors Guild versus Google, thinking of PDF documents and documents online, in the digital reproduction of documents. I don't need a 3 there. I think it's on the next page. Utility and design patents. If you replicate the thing that's patented, then if you sell that, you are infringing on the patent. Just the act of replicating it and putting it on your shelf is not infringing on the patent. But it's when you try to sell it and make money off of it somehow. Here's a couple I found. Apple versus Samsung. This one actually, Apple has, there's a whole, in fact, there's a website tracker that does nothing but tracks the patents that Apple submits, because there are thousands of them. And one of them that they submitted at, this was 2016, Samsung was infringing on, and turns out that Samsung had to pay $1 billion in damages to Apple over that infringement. This one, I don't actually remember what this one was particularly about, but the important thing here was that the interpretation resides with judges. So this one was actually in front of a jury, was decided one way, and then the judge, a higher judge, actually reversed the decision in the opposite direction. Trade secrets, it's almost impossible to keep a digital file a trade secret. I mean, it's too easy to reverse engineer them. You can have like cybersecurity types of encodings and encryption that maybe that can deal with it, but then you have to have a way to decrypt or unencrypt the file in order to use it. So it's going to be hard to do that, but there are a couple of what does it mean to reasonably try to protect the trade secret. You can't just say it's a trade secret. You have to put up some effort to protect it. And then there was a mention that Defend Trade Secrets Act in 2016 that actually lays out some laws for what happens if somebody steals a trade secret. And then trademarks, you can't go and copy somebody's trademark. We could probably go on Etsy right now and find stuff that definitely is infringing on trademarks. Characters, you could probably find a 3D printed all kinds of characters. I know there's let's see, let's just look, because I said I know and I don't actually know that. Let's see if there are Pokemon 3D printed. So that one, you've got I'm sure that Pokeball is trademarked. These are definitely trademarked, but these are I assume custom 3D. I assume these are 3D prints. These are just renders though, so I don't actually know what they're selling. I don't think it really matters though, because those are copies of trademarked things. So you can definitely find people violating these trademarks. You've got a couple of, there's the Lanham Act I talked about that governs it. Here's one where unauthorized reproduction of trademarks. So you do have to be careful with those kind of things, because one thing about trademarks is that, let's say that you are printing something related to Pokemon, since that's what we just looked at. If the Pokemon company does not, I don't remember, I think that's actually their business name, but I don't know. But whatever it is, if they don't, whoever that owns the trademark, if they don't go and tell you to take it down, then they set a precedence of not enforcing their trademark. And that causes them to lose power in their trademark, and it makes it easier for the next person to come along and copy the thing. So if you don't enforce your trademarks and your patents, then you lose legal power on, you're not using the trademark, particularly trademarks. Nintendo is always submitting cease and desist acts to anybody that has anything related to Nintendo out there. In fact, you may not can find, I didn't think about that. Let's see if there's something that looks like a Nintendo. Well, I'm surprised that's out there. These probably get taken down pretty regularly. Not this kind of thing. So here they're just saying, hey, here's your cool stand for your Switch. That's not infringing on Nintendo. But the one that says Nintendo, it even has the circle R thing up here, or that's going to get taken down at some point. That's definitely violating their copyright. I mean, they even put the circle R on there. That's not gonna stay for long, although it looks like they've got 188 sales, so I don't know. Those kind of things, if Nintendo doesn't regularly go along, periodically and take all these things down, then they lose some power on their trademarks. So hopefully that gives you a kind of general idea of the types of intellectual property, maybe some of the ideas that you can use to protect them, how you can avoid violating anything as far as a trademark or a copyright or a patent. It's fine for personal use. If you just want to put them on your shelf and print them out, that's fine. Things like we looked at the deal here where we found something on Thingiverse. We looked at its license that it wants you to use. Again, this license doesn't actually, it's not legally binding, but it at least, when you click on it and it says that, oh, you can use it commercially, then they're not going to even try to enforce any kind of copyright. But those are some useful tools for 3D printing, because 3D printing can go out and do a lot of things. You can copy a lot of things. You can find, you can go to GrabCAD and get all kinds of files of things that are real world objects, and you can make your own version of it. Just need to know when when you're violating something versus not. In general, if you're not making money from it, like you're just personal use and you're putting it on a shelf or whatever, then you're probably fine. But the instant you start taking something that's trademarked, copyright, patented, and try to make money from you reproducing that thing, you're not okay. Are they going to come and hunt you down? It depends. You know, did they happen to see your money-making plan there or not? Probably not. But it is possible. You would be in the wrong if you were trying to make money off of one of those things, all patents, copyright, trademark, without the permission of the assignee or the owner of those intellectual property pieces. All right. Like I said on Friday, I think we're going to do some techniques on, you know, how do you go about maybe finishing some of your models in different ways. If I could get the screen off of there. I don't know what's going on there. There we go. How you get different techniques. I've got a couple of different things that work pretty well. So we'll probably spend most of Friday doing that. If our fan comes in by then, I don't think it will, but if it does, then we'll look at that. Maybe we'll go ahead and tear it down just so you can see what's in there. But if it comes in, then we'll try to fix that up and get back to printing there. All right, I will see you all Friday at 9:30.